2019-340, State of Arkansas versus Gary Gebhardt.
Your Honor, this is set for a final hearing on Mr. Gebhardt today. He's fairly recent as far as being appointed to us. Visiting with him at the jail, he has been in the Department of Corrections. He was brought back here. He's been in our jail since August 26th. Your Honor, I don't mind him reappearing on your November date, but I'd like to get him out of jail. And his bond, I believe he told me his bond was at $50,000.
Let me see. That was what the original bond was. I'm just going through this. Charges were filed a long time ago, but the warrant, this shows the warrant was not served until August 29th, or 28th, perhaps.
You know, I think what has happened here is he was sentenced out of Marion County. These charges actually arose before he was sent to Marion County, or to the penitentiary from Marion County. Which may or may not be an issue. I just need to develop
Well,
that.
the issue is going to be whether he was arrested on these charges prior to being sent out of Marion County in terms of a speedy trial issue, is what it appeared.
I understand, Judge.
Does the state have any facts on this?
The affidavit was filed in January of 2019.
That's what I noted, and that's what I'm concerned about. Because if it was filed, if he was arrested prior to that, initially, and then got out, then we may have to. Ruth, there's a lady in the first row who is motioning. She may have some information. Could you check with her?
You know, her information was the same that he provided me at the jail. I don't know his date of arrest, Your Honor.
I can tell you. I was arrested December 19th, 2018, but not on these charges. Was held in Marion County until February 26th when I went to ADC. February 28th, I was given a hold copy of this warrant, but never was arraigned.
Okay, what I'm going to do, in an abundance of caution, I'm setting this matter down for trial during the week of the 18th. I know we already have a number of cases set that week, but I'd like it looked into from that point of view before we set any other date. I'll order him to reappear for. We'll take this matter up on November 14th. Has he's on parole at this time?
Yes.
From his sentence out of Marion County?
Yes, sir.
He's not been violated on that parole, is my understanding, Your Honor. So if he can get a bond that he can make, then, Your Honor, he has a home that he owns at 158 Tollport Lane in Flippin. He's a resident of Marion County, and Your Honor,
I'm going to set the bond at $5,000 cash as surety, and make it a condition of his bond that he report weekly to his parole officer.
Thank you.
And I want that's report in person, so that he stays in good communication, subject to. So we have complete thing. And then I'd like counsel to investigate the facts of this case in terms of seeing if it can be gotten ready for trial that week of November 18th, and make sure that we're, continue it only if we're absolutely certain that we don't have any speedy trial issues, because it's really I don't want to take any chances on losing a case for speedy trial.
Yes, Your Honor.
All right?
Your Honor,
All right.
if he is able to get out, is he to reappear on November 14th?
He's to appear on November 14th. And in the meantime, you need to get hold of your parole officer on a weekly basis. You need to get in touch with Mr. Cooper, your defense counsel. Be in touch with him, and that's not always easy. So you're going to have to call the public defender's office and make an appointment to get in to see him, and then be here on November 14th. All of those are requirements that I'm imposing on you. All right?
Yes, sir. Thank you, Your Honor.
All right, you may be excused. (2019-100), 2019-98, State of Arkansas versus Clayton, Hatchet. I know, are we finally going to get a plea on this? It's been bouncing back and forth between here and Marion County for like 3 months, it seems to me.
Your Honor, it's my understanding we've made a plea offer, and we're waiting on Mr. Gibson to hear back on whether he's going to accept that offer.
Has anybody heard from Mr. Gibson about being here today?
I have not, Judge. I don't know if Mr. Etheridge has.
Okay. All right.
Your Honor, why am I being held here?
My best recollection is that you appeared in Marion County one day, and then I think we said we were going to take up your matter in Baxter County the next day, and then you didn't appear in Baxter County.
I was at both court dates, sir. I've been seeing you religiously.
Well, that's not how I recollect it. Maybe you were just out of the room when I called your case. But in any case, that would be my recollection, is that you didn't appear. Because I remember distinctly being very surprised that you didn't appear after having been in court in front of me the day before. That's what I'm remembering. So.
Yes, sir. I was definitely there. I initially was not in the room whenever you called my name, and my lawyer had gone out to the hallway to retrieve me, and I came back into the courtroom, and you discussed my case at that time. I was at court, sir. I've been here for a week, and I was so surprised whenever I got picked up for the failure to appear, because I had gone to both court dates, and I've been seeing you religiously. It seemed like on a bi-weekly basis. And have
you been in touch with Mr. Gibson anytime recently?
Not since I've been incarcerated for this last week, sir. No, I have not. But up until that point, of course, I have been and had been.
Let's see if we can't get hold of Mr. Gibson.
May I please be released, sir? Because I have not. I've been completely doing everything you wanted me to do. I've been showing up to court. I'm surprised my lawyer is not in court today.
Well,
Your Honor, may I step out?
Yes, you may. He's not regularly assigned to my court, so I don't know what the circumstances are with him. Until I talk to Mr. Gibson on your behalf, I'm not going to release you.
Please,
but I intend to do it today, sir. What I'm telling you, I want to talk to him, and then I will make a decision on what we're going to do with you. All right?
I've been going to court every single time I was supposed to be in court.
Your Honor, Mr. Gibson, I'd forgotten before I said that. Mr. Gibson had texted me this last night. He had court with Judge Baylor this morning over in Harrison. He said he would be here by as quick as he got done. He had the only case was on the docket. He thought he'd be here before noon, Your Honor.
Okay. I'm going to put you on the list of people to be brought over. We'll take your case up this afternoon, when Mr. Gibson can be here. You may be excused for now. 2018-348, State of Arkansas versus Jennifer Greer. I have Ms. Greer down for a revocation hearing.
I understand that we have just been appointed to represent Ms. Greer. I have not spoken with her.
Has she been arraigned?
I don't know, Your Honor, if she has been or not.
Yes, I have.
8.1. think she's at an 8.1, and I don't think she's been arraigned.
Petition on this matter was filed September 27th of 2019. That petition alleges that in September 10th, she failed to report to her supervising officer. On September 20th, it was discovered she was no longer living at her listed residence, so she did not maintain the residence. It's also alleged that she had failed to appear or cooperate with ACC, and she was believed to be evading supervision. So her failure in her obligation to cooperate with ACC. All of those are the allegations on the petition to revoke. On those allegations, how does she now plead?
Not true, Your Honor.
Mr. Cooper, you've been appointed to this matter?
We have been, Your Honor.
Okay. Plea of not true is noted on the record. She'll be set down for a hearing on November 14th. You may be excused, ma'am. Tylar Sutterfield, this is 2017-291. Mr. Sutterfield, have you made contact with an attorney?
No, sir.
What is your intention in terms of securing counsel?
Public defender, sir.
Well, you'll need to fill out a new application if that's the route you're going to go to. So those applications are there at the jail. You secure one, fill it out, and turn it in.
Yes, sir.
Your Honor, he was represented by our office, and this is the same case number on amended revocation. Mr. Dennis was representing him, so since it's not a new case number, I think we still represent him.
Back in August of 2019, Mr. Sutterfield, you were released and ordered to, the Public Defender's Office was appointed to represent you. I guess that was Mr. Dennis who was reported. Mr. Dennis is no longer with the Public Defender's Office, so you're going to need to get back with the Public Defender's Office for representation. But you were, my understanding is you were ordered to getting back in compliance with your probation officer back then, and this matter was set down out 60 days to be for appearance here today. Have you been in jail this whole time?
No, sir. I got arrested at court this morning, sir.
I see. Which court?
Your court, sir.
Okay.
Your Honor, he did come over this morning. He was arrested when he arrived this morning because of the new revocation.
Is there a new revocation?
It's an amended revocation based on failure to comply, Your Honor.
I see. So you've not had a chance to meet with Mr. Cooper or anybody else in the Public Defender's Office at this point?
No, sir.
Well, I'm going to order you to get in touch with the Public Defender's Office. The indication was that to me was that you've already had Mr. Dennis appointed to represent you. He's no longer with the Public Defender's Office. Especially if you get out, you need to contact the Public Defender's Office and make arrangements to get in to see Mr. Cooper or anyone else who may be assigned to your case. I'm going to put you down for hearing on the revocation on November 14th.
I'm sorry.
At this point, I'm a little bit baffled about, it's my understanding that you were being given the opportunity to get back in good standing with the probation office, and all you had to do was show up and go back on probation like you were originally. But it's because you did not do that that you've now been arrested.
Well, sir, I'm confused. The last time I seen Cody Gilbert, he told me I just got a new job working for Kelly Thomas. I work from 7 to 5. And from my understanding, he told me that if I kept this job that I wouldn't have to come and report every Monday to the class that I was taking. And that's what I understood. And I'm just confused, sir. I showed up to court this morning. I'm not trying to not show up, sir. I have a job. I have a house.
You do understand that you are on probation, right?
Yes, sir.
Okay. Well, probation, the only thing you really have to do to comply with probation is to show up.
Yes, sir.
And apparently you didn't do that. Now, I think it's really that simple, and maybe you just need to get back in touch with your probation officer. But at this point, the court has you down for a reappearance in this matter on November 14th, and we'll take it up then. You may be excused. How about Mark Hanson? Mr. Hanson, again, I would advise you that you're in that status where the formal charges have been filed. I'm looking at a file marked copy of the information. It indicates that you're being charged with possession of a controlled substance, methamphetamine, a Class D felony, and no seat belt. A bond has been set in your case at $5,000, cash or surety. And I'm going to order you to reappear in this courtroom on November 7th in front of Judge Putman when he holds court a week from today. You may be excused at this time.
Sir, I've been a long-time resident of this area. I've always appeared to my dates. I would request an OR bond, and I haven't seen counsel either, and I just can't. I don't know how to get anything done in here.
What's your intention with respect to counsel? Are you hiring counsel?
Excuse me?
Are you hiring counsel? That's your constitutional right to counsel. Means you have the right to hire whatever attorney you want to hire.
Well, if I can't get back to work, I can't really hire them. In other words, I'm going to have to request counsel, yes, sir.
Okay. Have you filed an application for the public defender's office?
No, sir.
Those applications are there at the jail. You can get one, fill it out, and turn it in. And that way, by the time you appear in front of Judge Putman next week, you can have a court-appointed counsel in place.
Okay. I do have a job, sir. If I could at least get a bond reduction, I believe I might have enough money to bond out. But as of right now,
where are you working?
Reps Roofing and More, just up the road off of First Street.
Okay. I'll reduce the bond in this matter from the $5,000 to $2,500. That's a cash or surety bond. All right?
Yes.
You may be excused. Your next
Yes, sir.
appearance, and if you bond out, you're ordered to appear in front of Judge Putman next Thursday.
Yes, sir.
All right, you may be excused. 2019-220, State of Arkansas versus Larry Keith Richardson. Mr. Richardson, my understanding is you're appearing here at this time in order to change your plea on charges against you pursuant to an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Have you discussed this agreement with Mr. Cooper, and do you feel you understand what the agreement is?
Yes, sir.
And are you satisfied with the advice and the representation Mr. Cooper's provided you?
Yes, sir.
on the charges as they're being amended by the agreement in this case of possession of a controlled substance, methamphetamine, a Class D felony, and possession of drug paraphernalia, a separate Class D felony. On those two charges, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement we talked about. The agreement is in writing in the document I'm holding up. It's called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And in going over the plea statement, do you feel you understand what it sets out?
Yes, sir.
You then do understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You also understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
When you plead guilty, you give up your constitutional right to a jury trial.
Yes, sir.
Along with that right to a jury trial, do you understand you're also giving up the right to be represented and assisted by an attorney throughout the trial process and to have a right to confront witnesses who would appear and testify during that trial?
Yes, sir.
And you're also giving up the right to appeal. That's the final
Yes, sir.
right. So you understand at this point the rights you're giving up when you plead guilty?
Yes, sir.
And understanding those rights, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you admitting or acknowledging that that on or about June 4th of 2019 here in Baxter County, Arkansas, you were found to be in possession of a quantity of methamphetamine and paraphernalia for its use?
Yes, sir.
Based on those statements, the court's going to find the defendant has freely and voluntarily entered his plea, done so after consulting an attorney, and admitted his actions that constitute the basis of the crime. On that basis, the court at this time formally accepts the defendant's plea and adjudges a plea of guilty and adjudges him guilty of possession of controlled substance, methamphetamine, possession of drug paraphernalia, both Class D felonies. In accordance with the agreement set out in writing in the plea statement, the court is sentencing the defendant to 5 years of supervised probation, subject to the standard terms and conditions of probation of this court. Those sentences will run concurrent with each other. The court is directing the forfeiture of items seized during the course of this investigation. The court is also imposing court costs of $200, a fine of $2,000, the statutory DNA fine of $250, booking administration fee of $40, public defender fees of $200, and a drug crime assessment of $125. All of those amounts will be due and payable as a term and condition of the defendant's probation. Payments are to be made in regular monthly installments of not less than $100 per month, beginning within 30 days of this date and continuing each month thereafter until paid in full. That'll be the order of the court. Attached to the plea statement are the written terms and conditions of probation, which the court has reviewed and signed, making them an order of this court that the defendant has to comply with these written terms and conditions of probation. The court is also directing the defendant, notes that the defendant has signed those terms and conditions, indicating he has read, understands, and will comply with the terms and conditions of his probation. At this time, the court is directing the defendant to meet with a probation officer in order to get set up on probation. You may be excused at this time.
All right, thank you.